What are exigent circumstances in New York? Exigent circumstances allow law enforcement in New York to conduct a search or make an arrest without a warrant when an urgent situation leaves no time for judicial approval. These exceptions to the Fourth Amendment's warrant requirement typically arise when there is an immediate threat to public safety, a risk of evidence destruction, or a suspect attempting to evade capture. Courts carefully evaluate whether officers had a legitimate reason to act without a warrant, ensuring that law enforcement does not overstep constitutional protections. If law enforcement acted improperly, any evidence obtained may be suppressed, significantly impacting the prosecution's case. Exigent circumstances under New York law requires officers to demonstrate a compelling need for immediate action to justify a warrantless search. The Court of Appeals has ruled that exigent circumstances must be supported by specific and articulable facts, not just speculation. In People v. Goki, for example, the court held that even when a suspect is lawfully arrested, searching their belongings requires additional exigent circumstances beyond the arrest itself. When law enforcement can ACT without a warrant for a warrantless action to be upheld, law enforcement must establish a compelling and immediate need for action. Waiting for a warrant would pose a serious risk. A lack of reasonable alternatives, officers could not have obtained a warrant in time. Objective and articulable facts, speculative concerns do not meet the legal threshold. New York courts reject broad justifications for warrantless searches, requiring a case-by-case analysis to determine whether officers had no other viable option. Common situations that qualify as exigent circumstances arise when law enforcement must act immediately to prevent harm, protect evidence, or apprehend a suspect. Courts analyze these situations carefully to prevent abuse of this exception. One well-established exception is hot pursuit, when police actively chase a fleeing suspect and must enter private property to continue the pursuit. Another recognized scenario is preventing immediate danger, such as hearing screams from inside a home or responding to a hostage situation. The risk of evidence destruction also qualifies in some cases, such as suspects attempting to flush drugs or delete digital evidence. However, courts closely scrutinize these situations to ensure officers did not have a reasonable opportunity to obtain a warrant first. How New York courts evaluate exigent circumstances. New York courts assess exigent circumstances based on the totality of the circumstances, ensuring that warrantless searches are not used as a blanket excuse. They consider the severity and immediacy of the situation. Was there a real, immediate danger? The availability of alternatives. Could officers have obtained a warrant without risk? Law enforcement's conduct. Did officers create the urgency themselves? Even when exigent circumstances exist, officers must also have probable cause before conducting a warrantless search. If probable cause is lacking, even an urgent situation does not justify bypassing the warrant requirement. Protecting your rights with the law offices of Jason Bassett, PC. While exigent circumstances allow for warrantless searches in limited situations, New York courts scrutinize whether a true emergency existed. If law enforcement acted improperly, evidence obtained may be suppressed, significantly impacting the prosecution's case. Challenging an unlawful search requires strong legal strategy and experienced representation. Jason Bassett, a dedicated Long Island criminal defense attorney, fights to protect clients' constitutional rights and hold law enforcement accountable for illegal searches. The law offices of Jason Bassett, PC, provides aggressive defense for those facing criminal charges and works to secure the best possible outcome. Call 631-259-6060 today to discuss your case. Visit our office at 320 Carleton Avenue, number 4200, Central Islip, New York, 11722, United States to schedule a consultation.